Appeals Division 1 is now in session.
Nope. We need to work on how we do that. All right, please be seated. All right, good morning, folks. We are here for oral argument in CV21-0684, Boyd versus State. As you may know, we record and are, I believe, live streaming these proceedings right now, so please, when you stand up, give your name and the client that you're representing. You have a maximum of 20 minutes per side. We do not obligate you to use all of that time, but you are free to use what you need. You do have to keep track of your own time. The clock will be running on the podium, and it is up to you to reserve some of that time for rebuttal if you would like to do so. Please keep in mind we've read the briefing, we've studied the record, we discussed the case this morning in conference, and with that you may proceed.
May it please the court, my name is Alex Egbert, representing appellant Glenn Boyd. I would like to reserve 5 minutes for rebuttal, please. At issue is whether the trial court erred in dismissing Glenn Boyd's childhood sexual abuse action that the legislature under HB 2466 had revived and gave him the right to commence before December 31st, 2020, quote, notwithstanding any other law, close quote. The state does not dispute that the trial court erred in its reasoning for dismissing Boyd's claim under the statute of limitations. The state instead argues that the trial court stumbled upon the right result because under a different statute, the Notice of Claim statute. But the Notice of Claim statute also could not have barred Boyd's claim. First and foremost, it could not have barred his claim because of that language, notwithstanding any other statute. Notwithstanding any other statute, Boyd had the right, his claim was revived, and he had the right to commence it before December 31st, 2020. He filed it December 29th, 2020. That is before December 31st. Therefore, under HB 2466, it was not barred.
Counsel, what do we do with the state's contention that, you know, we can look to California and other states that have been more clear in their statutory language? How do we deal with that?
I mean, quite simply, that's the California statute, not the Arizona statute. If the Arizona legislature wanted to make it so that every other Notice of Claim statute or pre-filing requirement still applied, it could have said that. It could have written something as the state inaccurately paraphrases HB 246. It could have said something like, notwithstanding any other law, the claim is revived, period. And those revived claims can be commenced before December 31st, 2020. That would have separated notwithstanding any other law from the right to commence the action and would have left open all other pre-filing requirements like the Notice of Claim statute. The legislature did not do that. And it's not the court's or anybody's place to insert that extra limitation into the statute.
Don't we have to harmonize, though? I mean, we don't read any statute in isolation. We have to read it in context of the overall statutory scheme. Is that something you'd agree with?
I'd agree with that. But recognizing an exception, a limited exception under specific circumstances, is what the Supreme Court in State v. Cash has called harmonizing. When a limited exception from a general statute, a specific exception is harmonizing. And I recognize that in the unpublished decision of this court, Doe v. Arizona Board of Regents, involving HB 2466, it said that harmonizing meant it needed to recognize no exceptions. Respectfully, that's contrary to what State v. Cash has called harmonizing.
Well, let me defend Doe a little bit, at least. Isn't it possible that harmonizing can be saying, when in a statute of limitations section that it says, notwithstanding any other law, the statute of limitations is extended, writ large, harmonizing is saying that notwithstanding any other law means notwithstanding any other law that contains a contrary statute of limitations. And then we would say, okay, well, what else is there? Is there not a notice of claim statute that still applies? And that's in harmony with this because we're not talking about a statute of limitations anymore.
I agree that that also is in harmony with it. I just don't believe that it's not also in harmony to read the statute more literally, as I believe the court must, and to say that HB 2466 recognizes an exception for all other statutes before commencing the action.
Counsel, would it be possible to harmonize the statute by reading the phrase claim presentation deadline as meaning exactly that, deadline, and not like a requirement? In other words, where I'm getting at here is, why couldn't it be read fairly or reasonably to say, okay, that deadline cannot bar a revived cause of action. It cannot serve, the deadline cannot, but why can't a claimant, a plaintiff, still comply with the other requirements of the notice of claim statute, i.e. file a notice of claim, as Mr. Boyd did, in fact, file one here? What would be your counter argument, or if you have one, or if you agree with that? Is that reasonable, what I've just outlined? I mean, in other words, you can still comply with the statute, the notice of claim statute. You can comply within that window, as long as the notice of claim precedes the complaint. What's wrong with that construction of the statute? So I give effect to both the House bill implementation, notwithstanding any law, is still giving effect to that, but also giving effect to at least a portion of the substantive portion of the notice of claim statute.
If I understand your question correctly, I would agree that the notice of claim, they can be harmonized in the sense that the notice of claim statute is still in effect in that it has the procedures to file a notice of claim, but what is specifically barred by HB 2466 is the language of the notice of claim statute that then, if the 180-day claim requirement is not complied with, that it says any claim that is not filed within 180 days after the cause of action accrues is barred and no action may be maintained thereon.
Right, and that would be a claim presentation deadline.
Yes.
Right? I mean, would seem to be a claim presentation deadline. I don't know why the legislature would have used that specific language if it wasn't referencing the notice of claim statute, quite honestly.
I believe, I'm sorry, I'm not quite sure I'm understanding. So
I mean, why would the legislature, we're not supposed to guess why the legislature, but we'll do that in argument, right? Why did the legislature use the phrase claim presentation deadline?
Because I believe the legislature probably had this statute in mind for the type of claims that would have originally barred an action and that it wanted to include in the actions that were then revived.
Like statute of limitations would bar or claim presentation deadline, like i.e. the notice of claim statute.
Yeah, so the legislature says all those childhood sexual abuse claims that were barred under one of those statutes, statute of limitations, notice of claim statute, are revived. And they may be commenced before December 31st, 2020, notwithstanding any other statute.
What about the state's argument that the notice of claim statute is pretty clear as to when a claim accrues? It accrues when a person basically knows or should know of the claim that he's been injured. That person has been injured or damaged. And the state's argument is that went into effect, or that was triggered on the date the House bill was became effective back in May in 2019. What's wrong with the state's argument there?
So we're assuming you're not accepting the primary argument that
per arguments. Yes.
Assuming it does apply, why did it not accrue on the date it became effective? May 27, 2019, I believe.
Right, correct.
The reason being that Boyd alleged that he was severely mentally ill, so I agree, that normally would be when it accrues, except under Notice of Claim Statute 1282(1)D, which has been interpreted to be analogous to the statute of limitations tolling provision for when a defendant is of unsound mind.
Was that raised in the Superior Court, counsel?
Inartfully, he raised that he was of unsound mind, and he filed petitions with the court and raised issues, and they weren't addressed by the court, but I believe he did all that he was required to do to raise the issue.
Yeah. So if I can sort of circle back and summarize your primary argument in this case is that notwithstanding any other law should resolve this 180-day dispute, right? That solves it. But as a backup, what's your best backup on that?
Our best backup is, first, he was of unsound mind, so it didn't toll until he was able to actually file that notice of claim. Second, even if he wasn't of unsound mind, the other plain language of HB 2466 says a claim that would otherwise be barred is revived. There's nothing in it that says it's revived only if it was barred before this HB 246 came into effect. It doesn't say that. It just says if it otherwise would be barred, it is revived. And so, yeah, what if we're assuming the notice of claim statute did apply, and he wasn't of unsound mind, then 180 days sure would pass, then it would be barred again. But then under HB 2466, it says those are then revived. It is kind of a, I think the state called it absurd, cycle of revivals and bars and revivals, but that is the literal interpretation of the statute. And inasmuch as it is absurd, it only goes to the fact that that is not what the legislature intended. The legislature intended for the notice of claim statute not to bar the revived claims.
Talk to us a minute about the 60-day rule requirement.
Yeah. I think James pretty easily solves that. James says...
I thought James said we don't decide this issue.
You're correct, sorry. I don't mean to overstate. That's what the court said. But the reasoning can easily be extended. And I'll explain. Let's see. So in addressing the other issue that was at issue in James, the court said, the clear, unequivocal language of Section 12-82101E creates a deadline for the public entity. Quote, Section 12-82101E does not set forth any requirements on the part of the claimant. If there are no requirements on the part of the claimant, then the claimant could not have been required to wait 60 days. So I think extending that reasoning under, arguably, yes, the different issue in James pretty much resolves
What about, go ahead.
I was going to say, let's say I disagree with you and think James doesn't touch this, and the 60-day your client had to present his claim before 60 days. Doesn't that just get us back to the first part of this argument? We still run into the House bill, and it says, notwithstanding any other claims presentation deadline, it may be commenced by December 31st, 2020. So even if James didn't say what it impliedly says, you still win, right?
Yeah, correct. Yes, agree. This argument again is assuming that the notice of claim statute is not carved out.
I mean, so in every other case, I could say, yeah, you've got to present it 60 days before and give them 60 days to settle the case or consider it.
You could say
that. But here,
yeah.
We don't have to decide that because the statute, the House bill says you get to file it on December, as long as you file it by December 31st, 2020, you're good, right?
That's correct, Your Honor. Yes. Yes.
Sorry, not to hand you a softball or put it on the tee.
Yeah, we just,
I'll forgive you.
let me push back a little bit. Our court, and to some extent the Supreme Court have both sort of opined on the purpose, or the underlying purpose and intent of this 60-day requirement, which is to facilitate the ability of the government to negotiate, to engage in settlement offers, to have that time to evaluate the claim, and to be able to settle it absent, the plaintiff running to the courthouse and filing a complaint. Why aren't we, first of all, bound? Are we bound by that sort of, I don't know what I call it, dicta or whatever it is, but should not we just keep following that sort of tradition and we'd have to work through that, and I don't know how exactly we would, but those cases are out there. So what's your view of that?
So as the court explained in James, that 60 days is targeted towards the state. It's to give the state the option, 60 days option to accept. And if it doesn't, then that time's up. And James specifically says they can't consider those policy objectives. It does go into it afterwards saying, if we were to consider, and then it goes into that discussion. But it only does it after it says it's not appropriate to.
So you could read James to say the Supreme Court's allowed to consider those policy directives, but we aren't.
It's allowed to do it in dicta. Yeah. It's not allowed to make it official holding. Yeah. If there are any other questions, I'll reserve any remainder time for rebuttal, and ask that the court overturn the dismissal of Boyd's claims. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the court, my name is Rebecca Baines on behalf of the state defendants. I think we can all agree that the primary issue in this case is what effect the House Bill 2466's revival provision had on the notice of claim statute. And I'll begin by addressing a few things that came up during my colleague's presentation, his argument. And the first is, what is the meaning of a claim presentation deadline as it's used in the revival provision? And I think it is pretty clear that that's a reference to the notice of claim statute, or at least that is included within that reference. But I believe that the statute references the claim presentation deadline to say that when the statute was passed, any claim prior to that point that had been barred because of a statute of limitations or a claim presentation deadline or the expiration of any other time limit, whatever that means, then those claims that were otherwise stale are now revived. And
may be commenced by December 30th, 2020.
Correct, and that they may be commenced by December 31st of 2020.
31st, sorry.
That's okay. But this language does not do away with the requirements and the conditions that are found in the notice of claim statute that apply to all other claims brought by a plaintiff against a government entity. That's the most straightforward and reasonable reading of the statute, that all the statute did was said we recognize that there are some claims out there that are time barred for one reason or another. They are now brought and they may be commenced. But just like with any other claim, those claims are still subject to the notice of claim statute if those claims are brought against the government.
I would find that argument a lot more persuasive were it not for the first 4 words of that paragraph.
The notwithstanding any other law. And sorry, the notwithstanding any other law, I think, should be read as a reference to claims such as, to what is referenced in the statute, things like an applicable statute of limitations, a claim presentation deadline, or the expiration of any other time limit.
Do you have, give me your very best case for the proposition that notwithstanding any other law means something other than any other law?
Well, I think the best case would be cases such as the Cassius decision, the UNUM case, the State versus Curtis case that discuss legislative interpretation principles, and that when this court
But none of those cases found a statute that says notwithstanding any other law means something other than any other law.
That's correct. This particular issue.
So is there any case you can point to in Arizona? I didn't expect you to survey Kentucky law. For
Sure,
this.
I didn't answer that.
That says, yeah, we know the legislature said notwithstanding any other law. We're going to find this law still survives.
Well, while it's an unpublished decision, I would point this court to the Doe versus Arizona Board of Regents case, which that's the only case that I can point this court
Did you guys,
to.
after, the Attorney General's office was on Doe, right?
Correct.
Did you guys file a motion to publish after the case came out?
We did. There was one, yes.
And what happened?
Which was denied.
Denied.
And then I believe there was also a petition for review filed that's been denied.
Denied.
Yes.
So what do we do with Doe? I mean, I have utmost respect for all my colleagues on any panel, even the ones I'm not a part of. Probably more of the ones I'm not a part of. But we're told that the memorandum decision from our court are just persuasive to the extent we find them persuasive. So what do we do with Doe?
Well, I think that as you said, the best it can be is persuasive, but I think that it is persuasive. One, because it's the only decision that addresses this issue that's at play in this revival statute. And the reasoning of Doe is also sound. What the court did in Doe was it says that it recognized that it's looking at two different statutory provisions. And when it is faced with having to interpret two statutory provisions, its goal is to harmonize them, to give effect to both, and to avoid an implicit repeal of another statute, which is exactly what the reasoning.
Did the court in Doe take head on, notwithstanding any other law? I don't see that they really explained that.
I don't believe the Doe decision really elaborates on that particular point. The argument was essentially the same, that the plaintiffs were now required to comply with the notice of claim statute because of the revival provision. So it didn't really grapple.
And don't we, in engaging in legislative interpretation and harmonizing statutes, typically find that a more specific provision, like, for example, the more specific revival language and notwithstanding any law provision here, would sort of prevail over the general notice of claim statute?
But before you get to this, to the applying the principle of we can consider whatever the more specific statute, whether that prevails over an older, more general statute, you only get to that step if the two statutes that you're considering are in fact in conflict, cannot be read together. And I think that the statutes that here can be read together by simply saying that the legislature has recognized that and decided that it's going to give this extended statute of limitations in this revival window to bring these claims, but it retains the notice of claim statute requirements that apply to all claims against a government entity. And here the legislature...
But the legislature didn't explicitly include that last part, but in the statute, what it did include was sort of a bracketed paragraph that starts with really unequivocal broad language of notwithstanding any other law, and then reviving despite a claim presentation deadline or the expiration of any other time limit. How do we not see those incredibly broad pieces of language as the way your colleague has described versus us then reading back into this revival provision, the notice of claim law?
Okay, a few points, and hopefully I answer your question. I think first, again, the reference in the statute to the claim presentation deadline as a broad language is a recognition of what particular claims it was reviving. Those that otherwise the government could have said, no, your claim is barred because you didn't timely service a notice of claim. And the second is that the legislature did not include in House Bill 2466 something that says, and these claims are subject to ARS 12821, are subject to claim presentation requirements, but doing so would have been redundant because ARS 12821 by itself applies really to basically any claim that's brought against a public entity or public employee. So the notwithstanding any other law, which is very broad, but I don't think it can be reasonably read as
saying notwithstanding any other law.
Well, I think another interpretation of that would also be that this phrase then gets rid of other potential laws, like the only things that really come to anybody to say for a jurisdiction or venue or other statutes that perhaps put conditions on plaintiffs' ability to sue generally or certain defendants. I mean, I think that would be...
Well, I think you have to read it entirely. Notwithstanding other law, ellipses, may be commenced. It doesn't say may be filed in any jurisdiction. It doesn't say may be venue or other things aren't applied, but it says, notwithstanding their law, these actions may be filed by December 31st, 2020. That's
correct. It says that they may be commenced before December 31st, 2020, which means that they may be filed, the suit may be commenced in the Superior Court, as a Doe court did recognize, but just saying that you may file a suit, giving a plaintiff a right to file a suit, does not necessarily mean that any other sort of conditions or impediments to filing a suit do not necessarily apply.
Right, so jurisdiction, because the statute doesn't say where, it just says when, wouldn't be affected, and venue wouldn't be affected, and
well, I think if you're just saying it may be commenced, then that's
okay.
Then it could be read broader to that point.
Okay. Let me ask you a question. Who do you represent?
The state of Arizona, and then the Department of Juvenile Corrections, although that is a non-jural entity.
Right. So let's talk about that a little bit. Your argument is that we should affirm the ruling below, even though it wasn't based upon this, because AJDC is a non-jural entity. Well,
the Juvenile Corrections, their jural status was raised in the motion for judgment on the pleadings, and I think it's correct. So yes, I think that can be affirmed. The dismissal of them was proper, and because it was proper, this court should affirm.
Did the court below rule on that, or was it just one that you raised?
It was just one that was raised.
Okay.
It was not expressly ruled upon.
So, but we can affirm on any basis supported by the record, and since it's a non-jural entity.
That's correct.
Okay. Do you represent Ms.
Lowe?
Ms. Lowe, or
Lowe.
Some, no, she was represented by different counsel below.
Okay.
And she has not been, to my knowledge, participated in the appellate proceedings. Okay. So it's just here on behalf of the state and juvenile corrections to the extent that they're a proper party. So again, to turn to the remaining issues, assuming that this court does agree that the notice of claim was required, the next question then becomes whether the notice of claim that Mr. Boyd submitted was sufficient, whether it complied with the notice of claim statute. Addressing first the tolling argument, that was not properly raised before and should not be considered by this court. But even considering it, Mr. Boyd did not allege sufficient facts that would allow a fact finder to find that he is entitled to tolling, which is what the test is at that stage of the proceedings. So he's not entitled to a tolling of any deadline.
Other than timeliness, is there anything wrong with his notice of claim?
The timeliness is one thing, and then the other thing is the failure to wait the 60 days between filing.
Okay, I'm sorry, I meant timeliness both.
Including
6 and 60 days. 6 months and 60 days.
Right, correct. Those would be.
Otherwise, it complied.
Yes.
Okay, and you guys don't dispute that he filed it?
No, okay. No. He did submit it. Our issues in this case are with the timeliness in terms of both the 180 days and the 60-day deadline.
And I know James says it didn't, as we discussed with your colleague, resolve this issue, but how do you read James as saying anything other than it did resolve this?
James does support the state defendant's position, and I'll point the court to two particular holdings from that case. The first is that public entities, by operation of law, through what subsection E in the notice of claim statutes, have 60 days to consider and accept a settlement offer. And the second is that a plaintiff
That's not in the plain language, counsel, of the statute.
Right. So the
I get that our courts have said that,
right?
Or Deer Valley or the Supreme Court, but that's nowhere in the statute.
Well, the statute does say that a claim is deemed denied after 60 days.
Again, as a matter of law, right?
Yes.
As a matter of law, 60 days goes by, deemed denied.
Correct.
What else does it say?
That's pretty much the extent of what subsection E says as to the 60-day requirement, which our Supreme Court has interpreted as saying that by operation of law, public entities have 60 days to consider and accept a settlement offer.
And couldn't you still do that even though he filed suit 5 days or 2 days after you mailed it?
Well, the problem with that is that then forces the state to basically to engage in litigation, which is one of the purposes that Deer Valley, and they've been recognized by courts, is a purpose served by the notice of claim statute. So to hold that a plaintiff is able to turn right around and file a notice of claim renders the notice of claim statute a technicality.
What do you mean by forces the state to engage in litigation? Would you have to file an answer before that?
Well, presumably, I mean, it would be put on the clock to do something, to either file an answer, a responsive pleading, or hope that the other side is willing to work with you, or to settle the case. But it still puts the onus on the state.
It's just the notice of claim just says you can get rid of me for $1 million, right?
Sure.
So it's a settlement offer.
Yeah.
And if the government were to cut a check for $1 million and hand it to the defendant
On day 59.
on day 59, it's a binding agreement. It's regardless of whether there's a lawsuit. I mean that's an issue for another day, and that issue is simply not addressed in the statute, right?
It is a separate issue, but I think it would be even if that is it would become a binding contract at that point. That's not really the question. Is whether or not, or how do we give force and effect to what the notice of claim statute means, and its provision that requires plaintiffs to file this notice of claims in the hopes that the government is going to consider it, to budget accordingly, to engage in settlement if it wishes to do so, and to possibly avoid unnecessary litigation.
Let's say you're right. Just for purpose of this case only, there's no evidence whatsoever that the state was prejudiced in any way by trying to engage in settlement discussions in this case.
There's not, but I also don't think that that's the question, or the test is whether or not the plaintiff was somehow prejudiced by his failure to wait the required 60 days. The notice of claim statute simply applies, and those requirements must be met, otherwise the claim is barred.
We won't reverse anything under the Constitution if it's just a technical error. We don't reverse. So why would we kick out a lawsuit for technical error? I mean, it would basically be a technical error because you weren't prejudiced.
I liken it to an argument that a plaintiff, taken outside of this context, filed their notice of claim 200 days after their claim accrued, and the state could rightfully make an argument that it's barred by the notice of claim, and case law is very clear that failure to comply with the notice of claim statute does bar their claim, even if there's no evidence of whether or
that
not
bar is textually in the statute, whereas your reading of the 60-day provision is not in the statute. Isn't that an important distinction between those two? It
is a distinction, and we do have to grapple with. This has not been addressed by any case. James is as close as we get, and it expressly didn't answer this question.
Right.
Let me ask you I'm sorry.
No, go ahead.
Let me ask you the question I alluded to with your colleague, is that, and you're not conceding anything. This is not a trap.
Understood.
But assuming that I'm right, or that he's right regarding the House bill saying, notwithstanding any other law, claims presentation deadline, etc., we don't have to decide the James issue, the question left unanswered by James, because this is a one-off case that says the 60 days, whether it's a presentation deadline or not, doesn't apply in this case because you can file your suit, commence the action on December 31st, 2020. Would you agree with that?
Yes, I would agree. If this court says that no, the notice of claim statute doesn't apply, that these cases are unique, they're accepted from the notice of claim statute, then you don't get
to not accepted, questions. But you've got everything has to be done by December 31st, 2020. It's not actually December 31st, 2020 is not actually October 31st, 2020.
Oh, I see what you're saying. So that would be, I suppose, another reading. But yes, that you only get to the 60-day requirement if you could say you just had to file your lawsuit and perhaps also file a notice of claim by December 31st, 2020. That's when you get to this issue. However, I think to give effect, again, in that situation, you're still trying to give effect to both.
Your big argument is that that's not what the House bill says.
Right.
We have to read it in context.
Yeah.
But if I disagree with you,
sure.
Then you would say we wouldn't have to decide the unanswered question left by James.
Of the 60 days,
yeah.
Yes. But that does also require a determination that essentially this 180-day deadline that is expressed in the statute kind of doesn't matter, that the plaintiff can file the notice of claim at any time prior to this December 31st, 2020 deadline, which again gets into that territory of what effect are we even giving the notice of claim statute in that case. And it's essentially none. It's essentially reading out those requirements that apply to all claims against government entities.
Is it interesting that the legislature chose the word commenced as opposed to filed?
at risk of trying to think about what the legislature, as Judge Brown said, what they were, thinking of when they're doing. I think it is interesting, but I think also that is, it could be incorrect, but consistent with the language and the rules of civil procedure talk about when an action is commenced, and this was referenced in the Doe case. So that could explain why their choice of using the word commence, which really, in litigation terms, should mean that it was filed. It had to be filed by that deadline. And then I would also, so I'm happy to answer further questions.
Could you touch briefly on accrual?
Yes.
Because it's the state's position that it accrued as of the date of, in May of 2019, I can't remember which date, but
right.
That's the accrual date for the purposes of the running of the clock for 108 days. Would it be because I don't see this addressed in the briefing, but would it also be your position that was the 1 year statute of limitations also accrued on that day? Because 12-821 says you have to sue the government within 1 year, correct? And from the date of accrual, when you know you've been damaged.
That is what.
Would it be the state's position that Mr. Boyd should have filed within 1 year?
It's not, and I think that question is answered by the commence by December 31st of 2020 language. So the state's position is that basically to give effect to the notice of claim statute, you have to determine an accrual date, which would be the May 2019 date. That's when. But
it seems like to me then you're discounting 12-821. You're saying, oh, that clearly can't apply. Well, but yet you're accruing 12-821-01, the notice of claim statute. How can you get away with that?
I think that is a reasonable interpretation because of what the language of the statute says. It just simply says that you may be commenced by December 31st of 2020. So if we read that as saying that's the last possible deadline to file those claims, that would be in conflict with an ARS 12-821-01, and then you would get to that section of saying, well, this is an exception to that statute. But it did not also do away with the notice of claim requirements. So if there are no further questions, the state asks you to affirm.
Thank you.
Thank you.
Judge Morse, you addressed some concern about how to deal with Board of Regents. I would point to paragraph 25 of that memorandum decision where they discuss the argument that was made and that they rejected, and that's a different argument than Boyd makes. As you guys...
How so?
The defendant there, the claimant there, according to paragraph 25, as the court characterizes the argument, argued that the exception, the notice of claim exception, comes from, according to Doe, because the bill provides that revived causes of action may be commenced before December 31st, 2020. So that claimant relied on the may be commenced language. We agree that if that's not what exempts the notice of claim statute, the notwithstanding any other law is what exempts the notice of claim statute.
Notwithstanding the law and claims presentation deadline.
Yeah, and so as was referenced, the Doe Board of Regents did not discuss the notwithstanding any other law language. If they would have, perhaps they would have decided differently.
Do you concede that the ADJC, Arizona Department, ADJC, yes, is a non-journal entity and that we should affirm the dismissal of that?
We do not dispute that they're a non-journal entity, but that it does not affect Boyd's ability to, it's mostly an issue of naming the wrong party, but
we should affirm the dismissal as to the ADJ's Arizona Department of Juvenile Corrections, but your argument is we should reverse the dismissal as to the state and the individual plaintiff.
Yeah, and I would quickly point out Lowe also should not be dismissed for the separate reason that the notice of claim statute doesn't apply to Section 1983 claims, which arguably is what Boyd filed. And case law says, although he did not identify it as a 1983 claim, case law says he did not have to. And one other last thing I would note is about the 60 days. There's nothing that I read in subsection E of 12-82101 that says the 60 days can't continue after an action commences. So even though the action commenced, that 60 days, the 60-day clock for the state to consider and the settlement still can go on. The state is still free to settle after the action's been commenced.
But it does seem, I mean, your colleague makes a great argument. Is what's the point of a settlement if they've still got to go and, I mean, file an answer, start the litigation clock, retain attorneys, assign it to someone from the Attorney General's office?
Yeah, I mean,
what is the point of all that then?
Admittedly, there's still, yes, there are those costs you mentioned, but it does save all the other costs after that point. Discovery, trial, the much greater cost.
I forget, what is the deadline for filing an answer to a complaint that's been served? Is it 45 days?
30 days? I don't know. It's been too long.
One of those.
Okay.
Yeah. But I think the points have been made, and my time's almost up, so I thank you for your time and ask that you reverse the dismissal and allow Boyd's claims to continue. Thank you.
Thank you, counsel, and thank you, Mr. Egbert, for your participation in the pro bono program of this court. With that, we will take the matter under advisement and issue our decision in due course. Court is adjourned.